On 25th December 2023, the Government of India notified three new criminal laws set to be enforced from July 1st, 2024. The Bharatiya Nagarik Sanhita will replace the Indian Penal Code, the Bharatiya Nagarik Suraksha Sanhita will replace the Criminal Procedure Code, and the Bharatiya Sakshya Adhiniyam will replace the Indian Evidence Act. In today's video, we are breaking down fundamental yet a crucial part of the criminal law, that is a FIR or a first information report. But before that, let's understand the two branches of law, that is a procedural law and the substantive law. Substantive law lays down the rights, duties and wrong. It tells us what is punishable, like theft, dacoity, robbery, etc. Procedural law tells us about the procedure about enforcing those rights and duties, including how an arrest is made, how the trial is conducted, how an FIR will be registered. For example, BNS, which is a substantive law, will tell us what a murder is, and BNSS, which is a procedural law, will tell us how the police will investigate that murder, how the trial will be conducted, and etc. Now, what is an FIR? Under the new law, the Bharatiya Nagarik Suraksha Sanhita 2023, the provision for FIR is mainly covered under Section 173. Now, it is the very first formal record of information given to the police regarding the commission of a cognizable offense. So, there are two kinds of offenses, cognizable and non-cognizable offense. So, according to Section 2, Clause 1, Subclause G, a cognizable offense is one where a police officer can arrest an individual without a warrant and can start investigation without prior magistrate's approval. Example, murder, rape, and kidnapping, dowry death, etc. According to Section 2, Clause 1, Subclause O, a non-cognizable offense is one where the police cannot arrest an individual without a warrant or cannot start an investigation without magistrate's approval. Example is public nuisance, defamation, simple hurt, etc. Now, in Section 173 of the BNSS, procedure for FIR for cognizable offence is also discussed. Every information relating to the commission of a cognizable offence, irrespective of the area where the offence is committed, may be given orally or by electronic communication to an officer in charge of a police station. If it is given orally, it shall be reduced in writing by the police officer, and everything that has been written, it should be read by the police officer to the informant. If it is given by electronic communication, it shall be taken on record and it shall be signed within 3 days by the person giving it. If the information is given by a woman against sexual offences, which are under Section 64 to 71 and 74 to 79 and 124 of the BNS, then that FIR shall be registered by a woman officer. And a person who is registering an FIR against these sections, and if he or she, that person, is mentally or physically disabled, then the FIR shall be recorded by a police officer at the residence of the person seeking that report, seeking to report such offence, or at a convenient place of such person's choice in the presence of an interpreter or a special educator. The recording of such information shall be videographed, and the police officer shall get the statement of the person recorded by a magistrate as soon as possible. On receipt of information relating to the commission of any cognizable offence which is made punishable for 3 years or more but less than 7 years, then officer in charge of the police station may, with the prior permission from an officer not below the rank of deputy superintendent of police, considering the nature and gravity of the offence, should proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case. If the information discloses a cognizable offence and is refused to be recorded, the person can approach the superintendent of police. The superintendent may investigate the case themselves or direct another officer to register FIR and investigate. Now, Section 174 tells us about the procedure for non-cognizable offences. When a police officer receives information about a non-cognizable offence, they must record the information in a prescribed book, refer the informant to a magistrate, and include the case in the daily diary reports sent to the magistrate. The police officer cannot investigate the case without a magistrate's order. If during the investigation of a non-cognizable offence, if it appears that a cognizable offence has also been committed, the case will be treated as a cognizable offence and investigation will proceed as per Section 173. Now, I'll also tell you about Zero FIR. That is a very important concept. Though it is not specifically codified in BNSS, Zero FIR is a recognized practice based on judicial directives and government circulars. A Zero FIR can be filed at any police station irrespective of where the offense was committed. It is especially important in cases like rapes, accidents, or urgent matters where delay can destroy evidence. Then the FIR is registered with zero serial number and later transferred to the jurisdictional police station. The purpose of Zero FIR is to ensure that justice is not delayed due to jurisdictional technicalities. What happens after FIR is filed? Investigation begins, collecting evidence, examining witnesses, arresting suspects. Police file a report. If evidence is found, charge sheet is submitted to magistrate. If not, if no evidence is there, then closure report is submitted. Based on this, the court takes cognizance and the trial began. Can an FIR be cancelled or quashed? The police themselves cannot cancel an FIR once it is registered, but the High Court can quash an FIR under Article 226 of the Constitution and under Section 486 of CrPC, especially if the case is false or malicious, if parties have settled the matter in non-serious offences, if continuing the case would be an abuse of process of law. Now I'll tell you about the key rights of the informant or victim. Either to receive a copy of FIR free of cost, to insist on FIR being recorded even if the police are reluctant, to approach superintendent of police or magistrate if FIR is not registered, and to know the progress of the case. So we come to the conclusion. So to wrap up, FIR is the foundation of a criminal case. It can be lodged for a cognizable offense under section 173, for non-cognizable offense under section 174. And don't forget, Zero FIR ensures no delay in justice due to police station boundaries. This is all part of the new criminal procedure code, the Bharatiya Nagarik Suraksha Sanhita 2023, which aims to make the process more transparent, accountable, and citizen friendly. If you found this useful, please like, share, comment, and subscribe for more such legal explanations in simple terms. Thank you.